Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. We are going to start on voting list 20, which is a continuation from the list that we had last voting session. Does everyone have voting list 20? Okay. And we're going to start off, Josh, you've got the first couple. Are you ready to go? Sure. Let's go with, yes, House Bill 30.
House Bill 30 requires the Department of State Police to establish approved rates for tow companies involved in police-initiated towing and recovery of light-duty vehicles. The approved rates must be based on recommendations made by the Committee on Rate Setting and Complaint Resolution for Police-Initiated Towing and Recovery, which is renamed under the bill. And the bill also expands the committee's statutory responsibilities. This is the cross-file to Senate Bill 578. Which passed the committee and the House and the Senate floor unanimously. The bills are not identical. There are some non-substantive differences. Speaking to counsel over in the House, we think the House version is the better version. Again, there's no substantive difference. There is one technical amendment which needs to be made, which that amendment is in your packet. It's number 183524/1. It simply strikes the bill, the word commercial when referring to commercial motor vehicles somewhere in the bill because that references to light duty vehicles, which because they are 10,000 pounds or less, don't technically qualify as commercial vehicles. So that's just a technical fix that they'll make over there as well.
You're missing what I'm saying. I'm joking.
Can you tell us why that?
There's a few, let me run through the differences here.
My good seatmate here was her bill. No. Curious why.
So House bill, there's certain change in the Senate. So an identical change was made in both bills to the body of the bill, but it was not reflected in the purpose paragraph of the Senate bill. So the House bill has that. The House bill added some language clarifying that the state police are supposed to set the rates based on recommendations from the committee, which I understand to be the practice, but it wasn't reflected in the statutory text. So the House bill just has that clarifying change. There were additional places where the House bill made this correction related to the definition of commercial motor vehicles where the Senate bill did not. And then the House bill also made a change to the name of the committee just to reflect the fact that it now deals with light duty vehicles in addition to the medium and heavy duty vehicles. The Senate bill did not make that change to the name of the committee. And then there's a change on the last page of the bill where it adds the responsibility of the committee. Again, the changes were substantively identical, but the House bill tabulated their version slightly differently. So those are the differences between the bills.
All right, so move the amendment. Is there a second? Is everyone okay with being recorded in the affirmative? Now the bill's before you as amended. Motions for favorable with the amendment. Is everyone okay being recorded in the affirmative? Yeah. All right. House Bill 30 with the amendment passes unanimously. We'll now move on to House Bill 107.
So there's House Bill 107 is a bill which creates the Intelligence Speed Assistance Pilot Program, which is when an individual has their license suspended to drive based on accumulation of points for certain offenses related to speeding or reckless driving. They would be able to participate in this program where in lieu of a suspension, they could install this device on their car, which limits how fast they can go. So the House and the Senate passed different versions of this bill. And just to give an update, it sounds like the House is willing to accept most of what the Senate did. They're still working out some of the finer details. I think I'm expecting the House to send me over a reprint of, what they're comfortable with. And so as soon as I have that, I'll share that with the members of the committee.
All right, House Bill 315.
House Bill 315 provides that a certain landlord may not refuse to rent to a prospective tenant who pays rent with the assistance of an income-based housing subsidy under certain circumstances. It provides that a certain landlord may collect financial information from a prospective tenant under certain circumstances, and provides that a violation of the Act is a discriminatory housing practice and is subject to enforcement by the Maryland Commission on Civil Rights. There is an amendment in your packet. It's from Senator McKay, and it provides that, if you look on page 3 of the bill text, it provides that a landlord or resident of residential property may refuse to rent to a prospective tenant who pays rent with the assistance of an income-based housing subsidy on the basis of any commercially reasonable and non-discriminatory use of subparagraph 1, a reference from a previous current landlord of the tenant, or 2, the tenant's history of violating a lease, failing to pay utilities, creating a nuisance, or damaging property. The new text is failing to pay utilities, so a landlord can take into account a tenant's history of not paying those utilities.
All right, so there's a motion to adopt the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right, now the bill's before you as amended. This motion is for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. House Bill 315 with the amendment passes unanimously. All right. Okay. This is House Bill 467.
House Bill 467 is the cross-file to Senate Bill 822, which is already passed over to the House. The bill establishes that the Maryland Parole Commission does not have the authority to permanently deny parole, and that an incarcerated individual is entitled to a subsequent parole hearing at specified intervals based on the length of their sentence after each denial of parole. In addition, the bill alters various requirements for parole hearings, hearing examiner and parole commission panel decisions, hearing recordings and appeals of parole commission decisions, and requires the parole commission's annual report to the governor to include additional specified information. There is an amendment in your packet. It is number 633125/1. This amendment makes the bill identical to Senate Bill 822 by adding a provision which prohibits counties from being a party to certain administrative proceedings regarding compensation paid to individuals who are wrongfully convicted and incarcerated.
Just to adopt, the motion is just to adopt the amendment.
Is everybody okay?
Is everyone okay with the amendment? And then is everyone okay just being recorded in the same posture that you had last time? Yeah. All right, so that's, Fulton's down, West down.
Yep,
Mike
Fulton,
down.
West, and McKay.
See what's the final.
7-3.
House Bill 467 passes with the amendment 7-3. Is that right?
Yep.
All right. All right, so let's go ahead and 573, have Shamari introduce it, and then we'll have Senator Sidnor speak on it.
Senate Bill 573, House Bill 573 alters the state statute related to housing discrimination to prohibit a person from acting in a manner that has a discriminatory effect. The bill also specifies that the prohibited acts of 20-705 of the state government article are discrimination regardless of intent. However, a person has not violated a prohibition of 20-701 if 1, the act was without discriminatory intent, the action was necessary to achieve one or more substantial, legitimate, and non-discriminatory interests, and 3, the person could not have achieved the substantial, legitimate, and non-discriminatory interest by less discriminatory means. The Senate bill passed with amendments, and the differences are that the Senate bill contains non-codified text, clarifying that the bill is not intended to abrogate existing case law or federal regulation. It also strikes language from the definition of discriminatory effects, if you look at the bottom of page 3 of the bill. Yes, the amendment is drafted, but it's missing one sentence that wasn't included in the final reprint. And so we can add that sentence in line, or we can just admit or adopt the amendment as it is drafted, and then that sentence about the insurance exemption, we could adopt that as a second amendment.
All right, got it. So we're gonna hold House Bill 573 until tomorrow. We're gonna get back to it tomorrow. So hold. We'll just get the amendments situated, and once that's done, we'll have a better discussion. All right, let's go back up to House Bill 187.
Thank you, Mr. Chair. House Bill 187 expands eligibility for an expungement under 10-110 of the Criminal Procedure Article to include a charge that was not disposed of by unequivocal conviction, but was instead disposed of by the court with no finding, designation, or included in a case that was designated by the court as having been terminated without finding. The Senate version of this bill passed in a different format. The Senate adopted language that had been developed by the state judiciary over the interim. So it would be to conform.
Motion to conform.
Second, there's been a motion to conform to the Senate. It's been seconded. Is everyone okay with that? All right, now the bill's before you. Motion's for a favorable.
Second.
Second. Oh, hold on, with the amendment, yep. Senator, hold on.
Are we conforming it to?
We did conform to the Senate.
Voted in favor of the Senate version, so I'm reporting everybody.
Yeah, everyone's good. All right, so House Bill 187 with, as amended, passes unanimously. House Bill 1218.
House Bill 1218 requires the Office of Tenant and Landlord Affairs within the Department of Housing and Community Development, in collaboration with the Office of the Attorney General, to develop a plan to identify severe health and safety risk properties in the state. It expands the structure of OTLA to address severe health and safety risk properties in the state. And 3, provides effective interventions to mitigate predatory, non-compliant, and negligent landlords of multi-unit rental properties in the state. DHCD must submit the plan and recommendations to the Governor and General Assembly by August 31st, 2027. The bill takes effect July 1st, 2026, and terminates December 31st, 2027. The amendments would apply, or if we're going to apply the House amendments and not conform to the Senate, the House applied the section to properties with 50 or more units. There's a statement of legislative intent, and it requires the office to communicate with counties and municipalities to seek input from renter and landlord stakeholders, and it adds an additional reporting requirement. No, it's just it would be a move favorable.
How many units was the Senate version? 10?
I don't think there was a number. I think it was all units.
That's what I'm saying. So the Senate version had no number, and their version had 50 or more.
Correct.
So why
This is the House, this is the difference between the House version and
Yeah, I would take, can we make a motion to conform it to the House version?
Well, it would just be straight favorable. It would just be a straight favorable. Yeah.
You just did?
No, it would just be a straight favorable on the House
Oh.
version, yeah. So motions for favorable on the House version. Second, do you want to just do a roll?
We moved the Senate version. And it's in a different posture. Does that bill still move forward and create conflict, or?
They're going to conform it to the House, so they'll both be the
We
same.
don't put that anywhere, or does it just go to conference?
It'll come back, it'll conform to the House and it'll come back here and we'll just say yes.
Okay, all right, thank you.
Yep. Do we need a roll call on that, or?
No, I'm
All right,
good then.
is everyone, okay. So, House Bill 1218 passes unanimously. All right, we're still working on amendments for House Bill 1017, so we're going to hold until tomorrow. And that will complete the work on voting list 20. Let's go to let's knock out Shamari, just for voting list 21, House Bill 600.
so this bill was from Finance, JPR Secondary, and Senate, or House Bill 600 makes several changes to the public local laws of St. Mary's County. The bill alters the fines and administrative enforcement actions that the county and the St. Mary's Metropolitan Commission may impose for certain misdemeanors, civil infractions, and other violations of METCOM rules and regulations. The bill increases from $25,000 to $250,000 the minimum amount of the bond that the treasurer or any deputy treasurer appointed by METCOM must give to the state, METCOM, and the county commissioners. Finally, the bill authorizes rather than requires METCOM to cause studies, plans, and estimates to be made for new facilities and portions of the county designated as not planned for service by the county comprehensive water and sewerage plan. There was a delegation letter. I did not print that out and put in your packet, but we do have it.
All right, there's a motion for a favorable. Seconded, is everyone okay being recorded in the affirmative? All right. Yeah, just one second. House Bill 600 passes unanimously.
Senate Bill. Senate Bill 1003 alters the salaries of the Howard County Sheriff and the Howard County State's Attorney by establishing the following salaries for each office.
Hearing on Friday, it's a Senate bill we had, and so it's on here, it's a salary bill, but you can just describe what it does, and it's not on the list, though. It's not on the list. It's not? Is it?
It is,
Which one?
voting list 21.
Okay.
There's 2 21s that were put out there, one only had one and the other had two.
Clean that up.
No,
You got a date stamp, please. Can't just give me 20 versions.
Senate Bill 1003 alters the salaries of the Howard County Sheriff and the Howard County State's Attorney by establishing the following salaries for each office. One, for calendar 2027, $220,601. For calendar year 2028, $227,230. For calendar 2029, $234,079. And four, for calendar 2030 and annually thereafter, $241,149. Pursuant to constitutional requirements, the salary increase take effect at the beginning of the next term of office.
Is that for both of them the same rate?
Yes.
Look, I hate to do this, but we've had that sheriff's bill sitting over there in judiciary. I'm trying to get a meeting, but that's local courtesy. This is the 4th year in a row, actually 5th year in a row. We've tried to move and give parity to the sheriff in Frederick County, and now we have a sheriff's salary for Howard County that we're trying to push through on their behalf. And look, I'm all about supporting that. However, we can't continue to say that it's not some type of bias when we don't know who's going to win the election. But because of somebody that's there, it's about the position, the responsibility, and the duties that entailed therein. And we're going to move another salary while they sit over on the one over there and not move it for Frederick County. So as a representative of Frederick County, I find that highly insulting that the Senate moved it and they're going to sit on it.
I'll put it this way, these are both Senate bills, Senate priorities. Do we have Shamari, do we have the House cross file of any of these bills? I assume not, because there's one amendment, it's a late
There is
amendment.
no
But
cross file for Senate Bill 1003.
do we have any other salary bills
In committee right now,
from the House in committee?
I can check very quickly.
On the House.
Salary.
We sent our salary. Senator Young presented the bill this year, so it's been a bipartisan.
Right, it's got bipartisan support. My problem is that we talk about bipartisanship and we talk about, local autonomy and local courtesy. This is 5 years in a row that bill is sitting there being held up. That's not local courtesy.
No, I hear you. Here's what we do. So I'd like to pass this bill since the Senate bill is going to go to rules, but we do have a House bill in possession. We're not going to vote on that House bill until the Senate bill receives action. Put it that way.
Okay, fair enough, thank you.
All right, just make a note of that. And we'll just go that way. Okay. Senate product. All right, so I'd like to move these, so we've got, did we adopt the amendment yet?
No, we didn't, I'm sorry.
To which bill?
There is no.
To this
1003,
sheriff's salary.
there's none. There's no amendment.
Okay, so then there's a motion for.
Move the bill.
Yes, favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Yes. Okay, excellent.
For local courtesy, yes.
Yeah. We pass it every year. All right. We're gonna go on to voting list number 15. We're gonna go to House Bill 306.
House Bill 306 is the cross-file to Senate Bill 297. It's identical. Senate Bill 297 passed the committee 9-1 and the floor 42-1. The bill prohibits a manufacturer, distributor, or factory branch from taking an adverse action against a dealer for disclosing on the dealer's website that the advertised price of a vehicle is the manufacturer's minimum allowable advertised price, and that the dealer may offer a lower price for the vehicle.
Motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Do we need a roll call? Recorded in the same postures? This is House Bill 306. All right, House Bill 306 passes 10-1. All right, Shamar, are you ready? House Bill 330.
House Bill 330 increases the number of members on the Board of Directors of the Maryland Legal Services Corporation and makes related changes. Specifically, the bill increases 1, from 9 to 12, the number of voting members. 2, from 5 to 7, the number of voting members who must be lawyers admitted to the bar in the state. 3, from 4 to 5, the voting members who must be non-lawyers. And 4, from 7 to 9, the number of voting members required to remove a voting member. The House bill is identical to the Senate bill. The Senate bill passed this committee 10-1 and 35-8 on the Senate floor.
I find this one of the more mystifying bills of the session. These directors are all volunteers. They serve without compensation on the board of the Maryland Legal Services Corporation, whose job it is to take money and distribute it to each of the counties, to organizations in the counties, which help solve the problem of indigents who need legal counsel. Again, the board members are all volunteers. They're unpaid, but they work. It's a working board. And the story I got was they're really busy and they need more help. So they want to increase the board from 9 to 12. That's what the bill is, to add 3 more volunteer, unpaid members of the board. I can't understand where the opposition's coming from. It just seems to me so obviously a good bill. So I was the sponsor in the Senate of the bill, and I will most emphatically vote in favor of this one. Thank you.
There's a motion for favor.
I don't want to be emphatically down. I'm going to be consistent.
There's a motion for favorable on 330. Everyone's going to be recorded in the same fashion that they were last time, so it's 10-1. House Bill 330 passes 10-1. All right, we're now going to move on to Shamar. Are you ready for House Bill 492?
Yep. House Bill 492 establishes a minimum adequate security standard for courtroom security at all courthouse facilities in the state. Any entity responsible for providing courthouse security must use best efforts to meet the minimum standards for courtroom security. Certain standards are applicable beginning July 1st, 2027, with additional standards beginning July 1st, 2029. The bill requires a court security officer to meet the qualifications for a special police officer as defined in 3-301 of the Public Safety Article. The Senate bill is identical to this House bill. The vote was 10-1 in committee and 43-1 on the Senate floor.
Second.
There's a motion for favorable. It's been seconded. Everyone's going to be recorded in the same posture as the cross file, which means House Bill 492 passes 10-1. All right, Jamie, you ready for House Bill 765?
Thank you, Mr. Chair. House Bill 765 adds leases of real property and rental agreements relating to real property to the list of documents subject to the prohibitions and penalties under 8601 of the criminal law article, which pertains to counterfeiting of private instruments and documents. It is identical to the Senate cross-file, Senate Bill 82. It passed JPR 10-1 and passed the Senate on third reader 37-5.
My objections to this bill. I was having a conversation with someone and they were talking about their child. They are an adult with an adult child that was trying to send their grandchild to a better school. And they were saying, oh, I'm gonna write a lease for my daughter as though my daughter lives here so that she can send her child to a better school. And I said, well, you better watch it with that because my colleagues would like to make that a felony. You sending your grandchild to a better school by having a fraudulent lease. I think when we look at the other instruments that are there, a lease agreement is dissimilar. In Maryland, a lease doesn't even have to be in writing. You can have a verbal lease agreement in the state of Maryland. And to take this and make it a felony, I think it's a step in the wrong direction. I scratch my head trying to figure out all the great work that we're doing to try to make our laws surrounding incarceration more fair, to make sure that we are putting people in jail for truly violent offenses and making sure that our criminal legal system has more fairness and more parity. To elevate a lease to a felony and to incarcerate people for lengthy sentences for it, I think is one of those reasons why, as we give with one hand, we take back with the other. So we will go through the heartache and pain of having these very, very great policies, and we will put them on the floor, we will get them through, and then we have very small ways that we chip away at them with things like this, where we put unnecessary felonies on the books for mostly, in a bill like this, people who are poor, people who are disadvantaged, and we are going to send them to jail for a lease. We don't have an exception in here for if you are a person who has been scammed by a company, because it's not just creating, it is the possession of a fraudulent lease, which would also be a felony under our laws in the state of Maryland. So I think it is a step in the wrong direction. I was the one vote that was no in committee on the Senate version, and I will be no again on the House version. Thank you.
Respectfully disagree. This is a bill that was introduced to try to stop squatting. On most of these squatting situations, the squatter has a lease, which they flash to the cop who comes to the door and says, see, I have a right to be here. These leases, when they are squatters, the lease is not real. It's a fake lease. But the cop doesn't know, because the cops aren't trained to recognize whether a lease is a real lease or a fake lease. So the squatter gets to stay in possession of someone's home for days, weeks, or months until it finally gets sorted out, all because of this fake lease. We got to stop it. So this bill is not intended to deal with the situation you describe, and it's possible that happens occasionally. I would suggest a bill next year to try to create an exception to this, to carve that out. But we need to stop squatting. It is a serious problem. And so I'm in favor of the bill.
Why put off till tomorrow what we can do today?
That's the scripture, oh my God, okay.
Listen, I told you my birthday was on Easter. I've been risen. I wasn't sure which way I was rising up, but
I'm glad you didn't ask me.
I know that's right. Is there a way to put that carve out in, that language? Okay.
So I think this is a good bill, and I think judges have the discretion necessary under current law to look behind the circumstances of the case. And if there's something uniquely empathetic, like the case you indicated, I think judges have the ability to rule based on those circumstances. I appreciate your hypo. I don't think it's going to be most of the cases. I think most of the cases are the very cases that were referenced here. Right. And of course, even before it gets before a judge, prosecutors also have discretion and can charge lower crimes so that people don't get felonies on their record. The problem is so pervasive, and the squatting problem, that is, and where it is happening is incredibly destructive to not only the neighborhood, but just people's sense of trust in their fellow human beings. The idea that you could go on vacation or be deployed abroad, and then someone just come into your home, and then you call the police, and the police say there is nothing they can do, strikes me as a real problem that we should solve this year, and that we shouldn't hold this up. So I'm in support of moving the bill forward if possible, please.
Thank you. One, I don't know that it's as cut and dry as you think, that squatters will be removed, that if a person presents a lease to a police officer, that they automatically will go. That's a fraudulent lease. I think that if it has the indicias of being a valid lease, I don't know that this will solve the problem of squatting in Maryland, and that we've cracked the code with this bill to criminalize being in possession of a lease that is fraudulent. I think that your point, Senator, about discretion makes me even more hesitant on moving the bill, because we've seen what happens with discretion. We have a lot of disparities in sentencing, and we have a lot of disparities in the complexion of our prison population, that we can attribute at least some of that to discretion. So if we leave this broad latitude on the books, and when we think about even just the discretion in the media reporting, if you were to believe media reports, you would think that everyone who was a squatter looks exactly like me. But I know that's not true. But that's what the media shows. And I think that when the media hyperfixates on certain stories, that's where the attention goes. And that's likely where a person would be criminalized as a felon with a felony record and would be sentenced to incarceration. And that's what happens when we put laws on the books like this and we leave the discretion to be our guide. So that makes me even more hesitant to be able to unleash something like this on the population. So I think there was a good compromise amendment that was put out there to say if our goal with this bill truly is to reduce squatting, then there's an opportunity to amend it to say if you're in possession of a fraudulent lease agreement and you're also in possession of the premises, then that's an opportunity to perhaps escalate a criminal penalty. But I think to simply have it be out there for possession of a fraudulent lease agreement, it leaves the door open for all sorts of abuses and to take us in a direction that we fought really, really hard as a state to walk back from. So again, I would say I don't think that this bill is ready for prime time, the bill or the policy. Thank you, Mr. Chair.
Chair, I also think this is a good bill. And the language of the current law into which we're inserting lease of real property says a person with the intent to defraud another. So I think that's important, that there's an intent to defraud. And then secondarily, we've had a number of these issues with squatters in my county and specifically in my district. And in talking with law enforcement, one of the things they said to me specifically is that the presenting fraudulent or forged leases carries limited risk for offenders. And so they are very much supportive of this, as am I. Thank you.
I was joking with Senator Folden earlier about being consistent because I voted for this last time, but you know, my thing is when you get additional information, when you hear things that you may not have thought of, what makes sense is to change your mind rather than be consistent. And after listening to this discussion today, again, what Senator Folden said, I mean, if there's an issue that we can correct, why wait until tomorrow, right, when we can fix it now? So I would hope that we would take what's been said under consideration. It would certainly make me more comfortable with being consistent with what I did last time. Otherwise, I may just be inconsistent.
I really appreciate what the ladies across the way, two different positions said. So I have to clarify. I was beginning to think about, we have put this in a counterfeit section. I'm not trying to second guess that, although I think it's not ideal. I don't think that's really where this fits completely. But what I'm trying to figure out is if the intent of the bill is to defraud, which I think is what you're saying, and I agree with you, then what Senator Henson is suggesting, which I know about these examples where somebody manufactures to some extent a residency to help a child get into a particular school. What I don't know legally, hey, counsel, I don't know legally whether when you do use, when you augment your position that your relative is living with you for purposes of going to school, I don't know if that fits into with intent to defraud. And if it does, then I think Senator Henson may be onto something, and we've got to work our way through maybe modifying this a little bit. But if intended defraud is really not always when, somebody's playing around with where their child lives, then maybe, the intended defraud is far more specific to primarily crimes of financial benefit, which even presenting you have a property that is not yours, you're obviously living there rent-free. So is there any understanding of, counterfeiting and the intent to defraud? Would fraud be a case where you present some document to augment your position that somebody lives at X address for purposes of getting somewhere? Would that still be fraud? Because that's a good question, I think, to understand.
If I understand the question correctly, Senator, is your question about whether fraud is merely an intent to mislead, or if it requires that you have intended to mislead for your own enrichment or to dispossess some, right? Sure. Right. Another bill pulled up the case law on what it means to defraud and what the required showing is. If you give me a minute, I can pull that up, or I can have it for you after the voting session.
No,
Sure.
I think that's from the deepfake. Is that from the deepfake discussion? All right, Senator Folden, go ahead, and then we're gonna make a decision here and move forward. Go ahead.
So I just want to be, again, I just want to reiterate, I do believe that we can fix this now. What I don't want to do is have any unintended consequences that we put someone in position of being a felon. And I didn't really think about the school stuff before. And I can tell you that as someone who there are people that have family members that live in other areas, that there may be a biracial family member, doesn't have the opportunities, and out of that in another county. But by living with them, they will have a better opportunity to go to a different school. If by doing that, that is a financial gain, because technically that person's supposed to pay out of county tuition to the county school system. Now, there are situations that, because the people are more concerned about the educational aspect and the opportunities for said student versus the additional benefits that say the actual family member, parent gets the benefits from the government if that person stays with them. It's more meaningful to the people taking the child in to put them in this school environment and this opportunity, if you will. There's two frauds happening right there, because technically they shouldn't be getting the additional services and fees from the state, but it means more to the people to have the person doing that. And the reason I bring this up is because that's my nephew. It's exactly what happened. So I don't know what this, like, if we're talking about squatting, let's stick with squatting, because the opportunities are so much more meaningful to have a student have the opportunity to live with someone else to enhance their opportunities beyond an arrangement where the school board could come back and try to make them a felon.
Thank you, Mr. Chair. I hear what everyone's saying, and I have no problem passing this, narrowing it to squatting. I just want to make sure that this committee in this discussion is not condoning making a fraudulent lease. I understand, sending somebody to live with somebody else to get, a different educational advantage, but I just want to make sure that on the record, we're not saying, hey, folks, it's okay to create a fraudulent lease. So, correct, an opportunity, but that's different than creating a fraudulent legal document to do that.
When you enroll them in school, are you not creating a fraudulent document when you put their address at your home?
That's not creating a lease. That's a very different document than creating a lease.
That's why I didn't say that. I said just documents that augment.
Correct.
Right. Yeah, I was
Correct.
careful
Yeah.
about that.
So I actually went to the model jury instructions on this particular statute. So in the model jury instructions, and I can also read another portion of this that relates to mental states generally. I'll just quote it directly. Although the state must prove that the defendant intended to cheat or defraud, the state does not have to prove that the defendant intended to cheat or defraud any particular person or that anyone actually suffered any economic loss. To act with intent to cheat or defraud requires that the defendant acted knowingly and willfully with the purpose to cheat or defraud. An act that is done merely because of mistake, accident, carelessness, or other innocent reason is not done with intent to cheat or defraud. The idea here is that, and I'll pull from the commentary on fraudulent intent. The word fraudulent in Maryland, as used in the definition of a crime, means a willful intention to defraud. Where fraudulent intent is a statutory element of an offense, our jury instructions follow suit and require that the jury be instructed that the defendant intended to deceive or cheat the victim. So deception is the key there.
I think if I read that right, that Senator Henson's point and Senator Fulton's point is well taken, that without some modification, the way we have this now, a lease, and I hear you, Senator Love, for whatever reason, if it is capable of and did in fact cheat or deceive or misrepresent, right, deliberately, willfully, knowingly, then they're all swept in. Now, I know we're focusing on one thing and we can change it. I don't know what the committee's will is, but I think what Senator Henson and Senator Fulton have brought up with those definitions is exactly right about that. That is a risk. It is swept in technically, even if it's not swept in practically. But there is a risk there.
I was going to say, now we know. And when you know, you need to fix it. Otherwise, the judiciary is going to say this was their intent.
now that we have actually put it on the record, and when they go back to find out what the intent was, they will know that this is what the note, regardless if we fix it or not, they'll know what the intent was. And therefore, I believe what the vice chair had said about this, with the judge having the discretion, we should roll this the way it is. This carve out added to it. I do not.
So, Mr. Chair, it's my understanding that I'll be developing some language for the committee to take up tomorrow. I guess just my initial thought is that in addressing that and discussing with the chair what the desired language would be, you could create a new section that substantially mirrors the language that's in the existing law that is in the bill now as it pertains to leases of real property or rental agreements relating to real property, but add an additional element that the person possess it or have created it with the intent to deprive another wrongfully or to wrongfully take possession of real property.
So we're going to work on. Yeah. Can you pass this to hey, Senator James? You can read some of this. Can you pass this down to her too? All right. Yeah. All right. So we're going to hold that for tomorrow. But, Senator Henson, your example though, it struck me because I was reading an article. Does anyone know who like Robert F. Smith is? So, the first black billionaire, I mean, the most wealthy person, African American, and he's an alpha man. Anyway, he talks about he's published several articles, but he had an article that I read recently. He talked about when he was growing up, he grew up in a segregated school system, but then busing started, and literally like half of his neighborhood was able to avail themselves to go literally across the tracks to a different school system. Because of where they were sectioned off. And there was a protest for busing in general to integrate the schools. And he had family members that then came and lived with him so that they could take advantage of it. 50 years, 60 years later, he talks about just the actual trajectory of the folks that got on the bus and the kids that did not. It changed his life. He goes to Cornell, becomes the first black billionaire, is probably the wealthiest African American in the nation. So that struck a chord with me when you said that. So anyway, so we'll hold it and we'll come back and continue work. So we'll now go on to House Bill 1030. Jamie, that's you again.
Thank you, Mr. Chair. House Bill 1030 adds a violation of 3708 of the criminal law article if the violation was committed against a judge or a judge-elect to the offenses and violations that may be investigated by the state prosecutor. The bill is identical to Senate Bill 634 as passed by the Senate. Senate Bill 634 passed JPR 11-0, passed the Senate on third reader 44-1.
There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, House Bill 1030 passes unanimously. All right, we'll now go on to House Bill, Shamar, you ready? House Bill 1110.
House Bill 1110 requires that a county or municipality, when filing a complaint for an in-rem foreclosure action on specified vacant property, serve the complaints on each interested party in accordance with the Maryland rules. This requirement replaces an existing requirement that the county or municipality, within 5 days after filing the complaint, send notice and a copy of the complaint to each interested party by first-class mail and certified mail, postage prepaid, return receipt requested bearing a postmark from the U.S. Postal Service. The bill takes effect June 1st, 2026. There was no cross-file, but there was an identical Senate Bill 819, and it passed this committee 11-0 and was 45-0 on the Senate floor. 730 was a cross-file, but it was withdrawn. Senate Bill 819 wasn't designated as a cross-file on the system, but it's identical.
And so the cross file are with reverse and the other one moved forward. They're not marked as cross file.
I'm still trying to figure this out. I was like, no, because we have these bills that come in asking for the seatbelts for the school bus and how much money it's going to cost. We always get these massive fiscal notes. And then someone came and was like, oh, I fixed it. I fixed the fiscal note. I was like, how'd you fix the fiscal note? How'd you do that? Well, we just made the locals pay for it. So Shamari, can you read the fiscal note? What's the impact and where's that money coming from?
For 1110? Okay. No.
So what, did he withdraw that?
No. Yes.
And Antonio, we passed Antonio's. That's right, okay. It's a direct cross-file, no amendments, right?
It's not a direct cross file.
No, it's not.
It's okay. It's an identical bill, but it's not a direct cross file.
It's an identical bill, that's all we care about.
Bill can be marked as a cross-file.
There can only be one, okay. All right, motions for favorable, it's been seconded, okay. I thought it was, no, that's my fault. If you look at House Bill 110, there you go. All right. It's like $4.3 million, it's okay. All right, Josh, you ready to go? All right, House Bill 1457.
House Bill 1457 is identical to Senate Bill 715, which passed the committee 8-1 and the floor 41-1. The bill authorizes the Circuit Administrative Judge for the Fourth Circuit to establish a truancy reduction pilot program in the juvenile court in Washington County.
There's been a motion for favorable and seconded.
So Senator Sidnor was down,
Stand down.
and then Senator James and Senator Colden were excused. How do you want to vote?
Yeah.
You're both up? Fantastic. Thank you. Okay,
So 10-1.
10-1.
All right, House Bill 1457 passes 10-1. All right, I think that's it for voting list number 15. We'll now move on to voting list 16, which are consent. That means they're identical to the cross-filed, and they were unanimous on the floor. But we need to. So at the request of the Senate cross-file sponsor for House Bill 11, there's an amendment forthcoming, so we're going to pull that off. And we're going to add it on, but we got to pull it off the consent calendar. Is there anything else that, any other bill that anyone wants to pull out? All right, so then, has everyone reviewed the list? Take your time. All right, so then there's going to be a motion for favorable on the consent 16 absent House Bill 11. Is everyone okay being recorded? Yes. Okay, great. So now House Bill 11 is before us, and Jamie will read it.
Thank you, Mr. Chair. House Bill 11 requires the Anne Arundel County Sheriff to appoint 3 majors at a salary to be determined by the Anne Arundel County Council. There is an amendment in your voting packet from Senator Guile. It's for Senate Bill 397, which is the cross-file, but they were requesting that this amendment language be placed on the on House Bill 11. Instead of requiring the sheriff to appoint 3 majors, the amended language would provide the sheriff may appoint 3 majors who shall serve at the pleasure of the sheriff at a salary as provided by the County Council of Anne Arundel County. So it makes it discretionary and clarifies that they serve at the pleasure of the sheriff. I do want to note for the committee that the Senate cross-file has already cleared both chambers and has been returned passed. There is nothing to do with that for the legislature beyond this point. So you would be creating 2 cross-file bills that have inconsistent language. In the situation where the governor signs both of them, the last to be signed would control. That would become the law. This came as a request from evidently the sheriff. I don't think that he wants 2 bills with different language, but he seemed to prefer having discretion as opposed to having a requirement that he hire 3 majors. That's my impression through different conversations. That would be the amendment here. It's giving more discretion than what the bill that was originally passed does. Yeah. They can no longer conform because the Senate cross-file has actually passed both houses. It's been returned passed.
Oh, so it's in the governor's desk.
So the delegation prefers this version. If we adopt it, they're going to articulate that to the governor. Yeah. Hold on. Yeah, sorry. Go ahead, Senator James.
In which we mandate the hiring practices to this degree of certainty for any law enforcement or sheriff. So I think, despite the Senate bill having flown out of here, regardless of anything else, the policy is better for the discretion. Not just would throw that out there. Okay, thank you.
So we're going to adopt the amendment. It's been seconded. Now the bill's before you as amended. It's motions for a favorable with the amendment. Yes. All right. Is everyone okay being recorded in the affirmative? House Bill 11 with the amendment passes unanimously. All right, so that will conclude our voting session for the day. I think tomorrow, the word is we have a double session tomorrow? Or
Yeah,
do
we have 1 bill hearing.
Yeah, just double session though tomorrow.
Yes.
So we're going to we do have 1 quick bill
It was
hearing.
reassigned to JPR.
It'll be quick. So we have a quick bill hearing and then we'll do voting in between sessions tomorrow. All right. There you go. God bless you. All right.